I am Scott Loughlin. This is the Data Chronicles, and here are your data points. Today we are discussing AI and antitrust and competition law in the United States. Listeners of this show might recall that we addressed this topic maybe a year or so ago. Well, so much has been going on that, including in connection with the new administration here in the US, that we need to get back to this topic again. As a reminder, today's episode is part of our ongoing and continuing AI Mastery series, where we discuss how AI is creating issues across legal disciplines. If you have not listened to our prior episodes and are interested in AI and the law, check them out. They cover material ranging from AI and copyright, intellectual property, energy policy, cyber, and so much more. It's really a great resource for anybody in the space. With that, let's dive into antitrust and artificial intelligence. Many may initially see the relationship between competition law and AI as attenuated, but I have actually learned that the opposite is true. AI is creating new issues in competition, consumer protection, and M&A, which are going to impact and are impacting how big and small technology companies chart their course in this rapidly developing market. To discuss, I've invited two of my colleagues, Logan Breed and Chris Fitzpatrick, to the podcast. Both Logan and Chris are senior members of our global antitrust and competition team, which Logan also leads. And as you are about to hear, AI is increasingly the focus of their day-to-day work. Logan, Chris, welcome to the podcast.
Thanks, Scott. Glad to be here.
Me too. Thanks, Scott.
Logan, maybe I'll start with you. I'm interested to hear from your perspective where you're seeing artificial intelligence and the different types of AI-based solutions out there and companies create unique competition issues, because I think maybe most people don't see a natural connection between AI and antitrust principles and competition law, and interested in where you are seeing those issues connect.
Yeah, thanks, Scott. Maybe I'll start with a 30,000-foot answer to that question. Chris could dive into more of the weeds of it. At a high level, regulators in the US and all over the rest of the world are increasingly focused on competition in digital markets and the impact that those markets and consolidation in those markets has on consumers. And AI is playing an increasingly large role in that, particularly because it is becoming more ingrained in a wider range of products and services that businesses and consumers are relying on. And I think that's a trend that everyone believes is likely to continue and accelerate. So we're seeing a lot of regulator interest in the antitrust space in big tech generally, and we'll talk about how the second Trump administration is likely to continue that trend, but also in acquisitions and investments. And that certainly influences how the new Trump administration and other antitrust regulators around the world are viewing AI.
And Logan, you mentioned one particular phrase there that I want to make sure I have my handle on, and I'm sure the listeners are also asking, the phrase digital markets. How are regulators interpreting that or kind of defining what the digital market is for them to assess what levels of competition exist within that market?
Yeah, that's a great question, Scott. And in antitrust parlance, a relevant market has two components. One is what we call the product market, and that is defined as the universe of viable substitutes that a consumer has if they're trying to do something or use a certain product. What are the reasonable substitutes for that product that consumer would have? If you raise the price of that product, would the consumer pay the higher price or would they switch to something else? And if the answer is they'd switch to something else, that something else is in the market. In the digital context, it's often very difficult to ascertain what the scope of that product market is, right? Because there are lots of products that could be used for a number of different things and might not be optimized for a specific type of application or solution, but could be used that way. And then there are also elements of dynamic competition that are somewhat unique in the digital space because change is inevitable in digital markets, and the products that are being offered today might not really actually be what customers are thinking about or using 6 months or 12 months from now. And then on top of that, you also have the geographic market definition. And in digital markets, typically that's global, but it doesn't have to be. And so the two elements, product market and geographic market, are together going to define the scope of a digital market, which is a very fluid thing. And often when the antitrust agencies are trying to review a transaction, one of the hardest things for them to do is figure out in the digital space whether the company's products are in the same market or how to define the scope of that market, what other players actually count in that market. And all of that's necessary to assess whether a transaction is likely to undermine competition in an antitrust market.
Got it. Chris, maybe from your perspective, obviously trying to define the market itself sounds like there is a lot to that. How are regulators kind of thinking about the unique issues with respect to consolidation in AI and kind of anti-competitive conduct with inside of those markets? How do you see that playing out in the regulator's mind?
Well, there's certainly some clues that we can get, Scott, although there's really some ambiguity to it right now, particularly as we look at the developing new priorities in the Trump administration. But I think big picture, there's sort of a few takeaways we can have on the perspective that the regulators are bringing to this. And maybe the way to think about it is they're kind of putting it into four different categories of potential concerns related to AI technology and the competition issues within that sector. The first is probably, as you mentioned, consolidation. And this is really a carryover from concerns that we saw coming out of the White House and the FTC during the Biden administration, where there were a substantial number of statements worried about how AI technology could be conceivably consolidated in certain larger firms. And then what are the market impacts of that? And there's sort of a twofold concern there, right? There's what's the market impact in the AI product market itself, to the extent one could be defined, and then how does it impact adjacent markets as well? As Logan said, we're seeing more and more integration of AI technology into everyday goods and services. And so when the upstream AI tech is conceivably consolidated or purportedly consolidated, the impact that has in other markets could also be a relevant concern. Outside of that consolidation, it's called a consolidation bucket, there's a few other concerns I think the regulators have. One is, how could AI sort of empower or underscore existing anti-competitive harms? So, for example, how could the technology be used? We see a lot of concern around algorithmic pricing. How could AI be integrated into big data analytics in a way that can have price impacts on a market, or could perhaps somehow contribute to excluding competition from a product market? So definitely some concerns there, although not specifically defined by the regulators in the new administration yet. Another category of their concern is around M&A activity. We've seen concerns from the last administration over investment partnerships between big tech and AI labs. Current FTC leadership has taken a more middle-of-the-road view on that, but Chair Ferguson has been clear that big tech is going to remain under the microscope. And so while we do believe that in general, the view of this administration and the FTC will be more favorable to deal activity, AI is one area where there might still be significant scrutiny. And then fourth, and this is maybe unique to our political moment right now in the beginning days of the new Trump admin, how do other socio-political goals from the White House implicate what the agencies are going to do? And an interesting sort of way to look at that would be, there's been a lot of commentary on censorship online of different political viewpoints and things like that. And the FTC is running with that and saying, okay, maybe this is a competition issue. So looking at all of those and how AI contributes to enhancing those kind of concerns is something that they'll be looking at.
And Chris, I appreciate the kind of the overview and the buckets, and maybe kind of that will give us a framework to use as we kind of try to dissect some more of these. I mean, Logan, I'm interested in your perspective about that consolidation issue, which I know we also talked about on our prior AI episode. Interested in how that's playing out in practice. So, like, for example, one thing that's been developing over the course of the past 12 months, say, has been around the development and uses of LLMs. And, the LLMs themselves can end up being a backbone to, much of the AI infrastructure. So even AI companies, it's very hard for them to create a brand new LLM. Instead, they would leverage the LLMs that are commercialized by others. But there are certainly a wide number of them, but there are prominent ones and that everyone is probably using, or that tends to be the most. And my guess is there'll be more and more consolidation around that in the same way that you saw in, the late 90s, having a number of browsers, and now everybody effectively uses like three of them. Or you're seeing a number of issues surrounding search engines, and now that market has consolidated. How does that, in your mind, play out with the consolidation of those key tenets of AI-based technology?
Yeah, it's a great question, Scott. And I think the answer is still kind of up in the air. There's been a lot of talk over the last year or two about the fact that there are some foundational inputs to AI: compute power, data, chips, coding talent, or the AI engineers. And a consolidation of those inputs could lead to a reduction in competition for AI. And antitrust regulators all over the world are worried about M&A activity sort of squelching a diversity of innovation and consolidating it in the hands of a relative few companies. In fact, last summer, the US DOJ and FTC, along with the European Commission and the UK Competition and Markets Authority, issued a joint statement on competition in generative AI foundation models and AI products. And they said in that joint statement that they were going to work together to ensure that the public reaps the full benefits of the development of AI, and that they recognize we are in a technological inflection point right now. And that requires, according to them, being, quote, vigilant and safeguarding against tactics that could undermine fair competition, end quote. So they were focused on things like the restriction of key inputs, that firms with existing market power in digital markets could entrench or extend that power into new AI markets or across ecosystems, taking advantage of network effects and feedback loops to increase barriers to entry for new entrants and to harm competition, or that a lack of choice for content creators among buyers could enable the exercise of monopsony power. So that's a focus that's been in place now for a while. And what's interesting to me is all of that rhetoric assumes that there is a handful of companies that are going to have access to those inputs that are absolutely necessary for an AI solution to be competitive. And that base assumption was called into question earlier this year when DeepSeek from China came out and was not based on quite as robust data set as people had assumed you need to have in order to have an effective AI solution. So I think that development has potentially slightly undermined some of the assumptions about how important it is to maintain a diversity of the key inputs when those inputs might not actually be as mission critical in some senses as we thought they were before DeepSeek's unveiling a couple of months ago.
Yeah, really interesting. Chris, I mean, from your perspective, how is the new administration kind of perceiving this consolidation issue in particular?
I think that they're trying to find a balance in how to do it. There's definitely, as we said a moment ago, remaining concerns about big tech and about consolidation in the industry among the agency leadership. But at the same time, they have, I think, clear policy instruction that deregulation is the order of the day. The White House, in the first week of the new administration, released a new executive order on AI that really fundamentally upended the approach that the Biden administration had taken. And that's more than just from a competition perspective. Many of the audience might recall that in the Biden administration, there was a substantial executive order on the safe and secure development of AI. And that included competition concerns, but also was really focused on safety, security, and process. How is the government going to be involved to ensure that the development of this technology is safe and is done in a way that's beneficial from a national security and human welfare perspective? The Trump executive order that did away with that really focuses on the primacy of innovation. And in fact, it directs agencies to review policies put in place as a result of the Biden era AI approach and to rescind those policies to the extent that they are holding back innovation. So we really do see, I think, the ground shifting pretty significantly there. So how do they find that balance? Well, out of FTC leadership, we saw a statement from Ferguson and Holyoke saying that they need to, quote, strike a careful and prudent balance. They are going to be looking, I think, to bring enforcement actions in this area where they think it is important. But, in their early days, I think that they also are looking for cases that can be won and looking for cases that they believe will have a tangible impact on consumers, something that maybe gets at sort of the kitchen sink economics issues that drives a lot of the sort of populist moment.
Yeah, I mean, it's really kind of fascinating as we continue to see that theme, right? Of the balance between the innovation and the regulation here. And it sounds like, add anti-competition laws and antitrust laws to the list where, that balance is continuing to have to be found. I mean, Chris, I'm also interested in your perspective on the next bucket that you mentioned, which was around the anti-competitive conduct issues. And maybe I'm thinking about this wrong, but I'm recalling a case from a few years back before generative AI started to get prominence. And that was around like effectively benchmarking services that were used for compensation. There are tools in place, where a bunch of companies had uploaded a bunch of data relating to how they paid their top senior executives. And then that got into the training algorithm. And then every company then could ask, well, how much should I pay my CEO or how much should I pay my CFO? And then that resulted in like, oh, well, this is how much you should pay them because this is how everybody else pays them. And then that resulted in effectively kind of a standard that was determined by the AI about how much people should pay their senior executives, potentially creating kind of a anti-competitive effect for having all entities in the same market have to pay their senior executives the same without the ability of any kind of fair negotiation. I mean, is that the type of issue that we're concerned about, or does it extend much broader?
Well, I think that framework is a good way to think about it, Scott. And when you talk about these issues around benchmarking and competitor collaborations, I think I would say I'm not sure the law has moved, but the regulators' view of it is certainly one that's moving and developing. And we've seen not just in the early days of the second Trump administration, but going back several years, real changes in approach there. There have been previous agency guidance, for example, on competitor collaborations that were withdrawn. And we've seen aggressive enforcement in benchmarking and information exchange type theories. So it's not entirely clear how the new agency leadership is going to approach that. And it's not entirely clear how they will in the AI sector in particular. I think it goes back to that balance we were talking about. And I suspect at some level, they're trying to discover it themselves as much as we're trying to uncover what they are doing. There's definitely an express sort of perspective from the White House, which is AI was overburdened under the past administration, and we're going to right the ship on that. And I think that the statements that you see, particularly out of FTC leadership, reflect that they've heard that message. But at the same time, they're taking seriously the obligation to police against anti-competitive harms where they see them. And so I think that when you think about things like benchmarking, and you think about allegations of sort of price information sharing, to the extent that AI and big data integrations are sort of supercharging the impact that has on markets, that's something they likely will continue to look at, particularly right now when consumers are so attuned to prices with all of the concern and all of the public attention, whether it be egg prices and inflation generally, trade wars. People are listening right now, and I think the agencies in the White House know that.
Logan, maybe I'm interested in your thoughts because, obviously the FTC plays a unique role in the US legal system, having a role of for overseeing competition law and antitrust law, but also overseeing areas of consumer protection at the federal level. And, this issue surrounding kind of the anti-competitive component sounds like it really triggers both the competition issues and the consumer protection issues, as Chris was mentioning. I mean, how do you see that playing out within the FTC in the way that they're thinking about AI?
You're correct that the FTC does have jurisdiction over both competition issues and consumer protection issues because Section 5 of the FTC Act prohibits unfair methods of competition, but then also unfair or deceptive acts or practices. And there are issues in both of those categories that are relevant to AI. We see it in a couple of the investigations that the FTC currently has going. And in fact, just 2 days ago, Bloomberg reported that the FTC's investigation of Microsoft, which started during the Biden administration, is going to continue in the Trump administration. That is a multifaceted investigation that involves a number of different elements, but includes an investigation of some issues regarding Microsoft's use of AI and some of the agreements or acquisitions that it's done in that space. That's all we know that's publicly available about the investigation. But I think the fact that the new administration has made the decision to continue investing resources in that investigation is significant. There's also this week some news on the FTC's case against Amazon, which is currently in court. It's a consumer protection case. And just a couple of days ago, one of the staff lawyers who is handling the case for the FTC went in front of the judge and said that they didn't have enough resources to continue the case because of potential cuts that DOGE is implementing, and they needed more time. And then about 2 hours later, sent a letter to the judge saying, I was wrong. I'm sorry. We have plenty of resources. And then yesterday, I believe it was on CNBC, FTC Chair Ferguson was asked about that, and he reiterated that the FTC is going to use all of the resources necessary to pursue big tech cases, including involving AI. He said that he's been saying since day one that big tech is one of the main priorities of the Trump-Vance FTC. It's one of the reasons the president appointed him to this position, and they are going to make every resource necessary to litigate those cases available. So I think that is going to continue to be a focus, and it's going to cover both competition and consumer protection issues.
Yeah, really interesting. So the third bucket that Chris laid out in the very beginning, and I think Logan, you also mentioned, was M&A. And I know maybe from two different perspectives, you and I had a chance to collaborate on a number of M&A deals in 2024, where it seemed as though that the central tenet of all of those deals was companies that were in the AI space. It seemed as though that everybody went through a rebranding effort, adding the word AI to their products and services, and that made it much more appealing for companies, for larger companies who are looking to invest heavily in the AI space through acquisitions. How do you see AI acquisitions in particular playing out with the FTC? And is there unique competition issues there that companies should be aware of?
Great question, Scott. And unfortunately, the answer is it's complicated, because at a 30,000 foot view, the FTC and the DOJ are going to be more favorably disposed to permit transactions to close without challenging them than the previous administration. We saw in the Biden administration a real philosophical opposition to M&A, to big companies getting bigger through acquisitions, that played out in the AI space as well as others. That philosophical opposition to M&A is now gone. However, it's complicated because, as I just mentioned, one of the targets of enforcement, based on the statements that the political appointees have made so far, is going to continue to be big tech. And a lot of the AI acquisitions are going to be done by big tech companies. So those transactions could still face antitrust scrutiny, even if deals more generally are likely to have an easier time getting cleared. You can see that in the comments that the Republican commissioners made on an FTC report that came out in January. The FTC has a statutory authority to do industry-wide studies. They're called 6B studies under Section 6B of the FTC Act. The agency can issue subpoenas, basically civil investigative demands, to a wide range of industry players on a given topic to learn about the industry and the potential competitive effects of conduct in that industry, and then issue a report summarizing their findings. They did that in the AI space, issued a set of subpoenas to big tech companies for a 6B study. And then in January, there was a staff report that came out that summarized the results of their scrutiny on corporate partnerships and investments with AI providers, so that they could understand the impact of those transactions on the competitive landscape. Now, the Republican commissioners have dissented from those 6B studies in the past. This time they did not, but they did issue an accompanying statement where they talked about that careful and prudent balance that Chris mentioned earlier with respect to the FTC's regulation of AI. And they cautioned against drawing broad conclusions from the report that AI partnerships are going to be bad or impact access to AI inputs that could have competition concerns. So it's a mixed bag, and we're going to have to watch this space to see how future deals actually are treated before we can be certain that general reduction in philosophical opposition to M&A is going to really apply here.
Yeah, really interesting. That strikes me maybe as one of my last questions. And Chris, maybe I direct it to you, because one of the things that I think each of you have touched on is the changing priorities within the new administration. And, we were seeing obviously that theme play out in all of the happenings in Washington right now, where the central premise is that, in some ways, the Trump Vance administration is trying to make the federal bureaucracy more responsive to the policy aims of the president, right? In the last administration, they would talk about the deep state as a means of trying to thwart the policy efforts of the Trump administration. Now it's very much focused of, well, all these people live in Washington, and Washington voters, voted primarily or predominantly for Biden, and so they are going to be essentially natural friction points and natural brakes on the Trump administration being able to implement its initiatives and its prerogatives and its priorities. So if I'm thinking about the connection here, right, between the enforcement of the antitrust laws and the Trump administration's political goals, how do you see those two things kind of fitting together at this moment?
Well, I think it's a really important question, Scott, and particularly if you look at it from the example of the FTC, it raises interesting questions right now about its status as an independent agency. When, as we've noted here today, that they have been quite responsive to, or I should say Republican leadership has been quite responsive to the apparent policy interests coming from the White House. I think that the Trump second administration has really been a paradigmatic shift in our politics and in the way that Washington has been functioning as we know it. And so when the AI sector, and candidly any sector, thinks about antitrust risk, whether that's through a business strategy or through M&A activity that they want to undertake, it's important to think a lot about how it's going to be viewed through that political lens. There's been several sort of tech-focused concerns that the White House and the FTC leadership have expressed. One I mentioned already today is the perceived censorship of conservative voices online, ideological bias, purportedly among certain tech firms. And then finally, a third, slightly different issue is the competitiveness of American tech businesses as against foreign competition, particularly foreign competition from countries that the government may see as adversarial. So just a few weeks ago, to give a more concrete example, the FTC published an RFI seeking comment on how technology platforms, in their words, deny or degrade, such as by demonetizing or shadow banning, users' access to services based on the content of the user's speech or their affiliations. Basically getting at the idea that users on tech platforms, social media platforms, have allegedly been demonetized, kicked off, limited in their audience because of the political viewpoint that they were communicating. And the statements associated with the publication of this RFI from the FTC reflect that they are trying to find a competition angle to that, sort of a way to use the antitrust toolkit that the FTC has to address this perceived problem. And it's not immediately clear how they intend to do that. If you read between the lines, there's some suggestion that they're theorizing collusion among tech firms to sort of put forward a certain ideology, and that in their view, that might have a reduction of output that you could sort of think through in a competition way. It could be a unilateral theory based under Section 5 of the FTC Act, which can be sort of broadly interpreted depending on how you read it. Or the angle could be that firms' ability to censor viewpoints reflects market power in a way that could underscore a monopolization theory or have implications for merger activity. And this is an area, too, where you can imagine the FTC flexing its consumer protection authority as well. But what's interesting about that is when the Trump administration returned here in its second iteration, there was, I think, a wide expectation among the antitrust bar, which I think was underscored and supported by some early statements from the transition and then from the White House and the early agency statements, that this was going to be a return to traditional antitrust. There was sort of this view that the Lina Khan enforcement strategies, for example, at the FTC, had been bold. They had been inventive. They'd gone to dust off old law and find sort of new paths to facilitate their goals. It looked early on as if that was going to stop, and we were going to have this return to traditional consumer welfare economics, and that would be the basis of these competition enforcement decisions. But what we see, in fact, is that when it comes to issues that are politically sensitive, issues that align with sort of the hot issue of the day from the White House, there's been some signaling from FTC leadership of a willingness to kind of open up creative ways to think about antitrust. We certainly see that in that request for information I mentioned on censorship. And also Commissioner Holyoake recently suggested at a conference that DeepSeek, the Chinese AI lab that Logan mentioned a few minutes ago, may have violated the antitrust laws in Section 5 of the FTC Act by using ChatGPT to achieve its technological results. So we really do see this willingness to get creative and to maybe stretch the boundaries of traditional antitrust when it aligns with these policy goals from the White House. And so businesses should think a lot, not just about the black letter law of antitrust and how that informs their risk, but more about how their products and services or the political perspectives that that company is known for would be viewed by the regulators and by others in Washington.
Fascinating to hear you describe that, Chris. And maybe I would ask, maybe one last question, because, the difficulty that, many of us have in connection with advising on these issues is that companies who are looking to deploy AI solutions are typically operating within a global market. And they're not just looking at the United States as their target or looking at a particular state in the United States, or even any particular region in the world. And of course, as you're describing, how the current administration is approaching these issues, it's very much with a sense of policy in mind, where it is that they want that to go. And that policy is not likely shared around the world. Right. In other words, if like any other administration, this administration disagrees with maybe the administration of member states in Europe. So how do you see the evolution of these issues playing out globally? And, as you're both work within U.S. law, but often working together with colleagues outside of the United States, how do you see global solutions to be either available or frankly unavailable on these competition issues with respect to AI?
Well, I certainly don't want to say that they're unavailable, but it does present a challenge for business. We see a strong recent history of regulation in this space in Europe as well. When you look at the EU's AI Act, all of their attention on digital markets regulation, it's a significant concern. And it's not entirely clear, particularly with so much uncertainty in the American regulatory space right now, how the requirements as between Europe and the United States and other jurisdictions are going to align. Companies are going to have to be nimble and be paying attention to these things. And in terms of a sort of one solution fit all, I'm afraid we don't have one, but it's something that can be navigated, but has to be done with caution for the reasons you identified.
Logan, maybe I'll give you the final word here on trying to bring that global strategy in mind. And in particular, maybe, especially because most people who are in this space, who are working through antitrust issues, are maybe not experts themselves in antitrust law. And, as to the extent they can glean it, it's probably going to be focused on their specific region. So maybe your thoughts on the importance of having kind of the specialized expertise here to not only understand the way the winds are blowing in the United States, but perhaps the way the winds are blowing in other regions when they are trying to strike this balance between innovation, policy objectives, and regulation.
Well, Scott, I'll go back to that joint statement that I mentioned earlier that the US DOJ and FTC signed on to last summer with the European Commission and the UK Competition and Markets Authority that indicated a very strong focus on ensuring, using the antitrust laws, that the companies that are currently leaders in digital markets don't automatically become the dominant companies in AI. Now, the US has had a significant political shift since then, which may, as we've discussed, reduce some of the philosophical opposition to M&A, but may not actually lead to less scrutiny on the big tech companies. And so there's a mixed bag, I think, in the US as to how exactly that's going to play out. I will note that the FTC chair, Andrew Ferguson, when he was sort of auditioning for that role as a commissioner after the election, but before Trump had decided who to name as the chair, there was a 2-page stat sheet on him that was released that became public, talking about why he should be the next chair and what his agenda was. And one of the bullets in that agenda was end the FTC's attempt to become an AI regulator. And another one was stop Lina Khan's war on mergers. Lina Khan was his predecessor as the chair of the FTC. But as I also mentioned just yesterday on CNBC, he was talking about how big tech enforcement is still going to be a focus of his. So in the US, it's complicated. Some of those other jurisdictions, I think, are still laser focused on this issue. And even if the US dials back its enforcement in the M&A area, may not go along with that and could decide to bring in and challenge cases involving US to US M&A in the AI sector because they believe it'll have a significant impact on consumers in their jurisdiction. I think we could also see enforcement in US states, if particularly blue state attorneys general think that the US federal agencies are dropping the ball on M&A in this area, they could go after deals that they think affect the constituents in their state. So to get the answer right, a company thinking about an AI acquisition needs to think globally and also locally, because there could be several different layers of challenge that it would face. And consolidating those risks, figuring out how to deal with them and address them in a coherent way that's going to resonate with each of those different regulators and their specific issues is a multifaceted task that really does require a global team to get it right.
Right. Global and interdisciplinary, right? In other words,
yes,
is the competition and antitrust angle, you've convinced me, is an important component, and that needs to be added to essentially kind of a robust team to cover these issues as they're presenting in so many areas of law. And so really appreciate both of your time and expertise on this show and sharing it not only with me, but with our audience. And so really appreciate your willingness to join today's episode.
Thanks so much, Scott. Appreciate it.
Well, with that, I'm Scott Loughlin. This is the Data Chronicles, and those were your data points.